Okay, they can issue subpoenas, and most administrative agencies do have a subpoena power where they can say, we need more information, you got to give it to us. Okay, much like a grand jury. Okay, now, two types of subpoenas. One is a subpoena to testify. Okay, now if you're issued a subpoena to testify, that means you have to show up in front of the agency and answer questions, and you have to do it under oath. All right. Can you attack it just like a desire for an inspection? You certainly can, but again, you'll probably lose, right? Again, this isn't criminal court, this is something more akin to a civil court, and the rules are much more relaxed, okay? Okay, so a subpoena to testify, you're given it, you show up, you answer questions. Most of the time you can bring counsel with you if you really need it. Okay, the other type is a subpoena to produce records, or a subpoena ducis tecum. That's just kind of Latin, and nobody knows really how to pronounce Latin, but anyway. But a subpoena to produce documents is just what it sounds like. Turn it over. Right? Produce these documents. We want to know over the last 6 months how many people have gotten sick because of this particular contamination. How many people have been diagnosed over the last 5 years with brown lung disease, white lung disease, black lung disease? Okay, that kind of thing. Okay, now, can you attack a subpoena to produce documents? Sure. Will you probably lose? Sure. All right. Almost always best to look like you're being cooperative, and if there are problems, to make sure that you're willing to remediate them in partnership with the administrative agency. Now, it's not to say, by the way, there aren't those situations where you say, hey, I have to go to the mat on this. I think this is wrong. They have no business knowing these things. It's a tough sell. It's pretty tough to do, but nonetheless, you do have that, the discretion, of course, to challenge it. Okay. Now, when it comes to challenges of inspections and subpoenas, generally you're focusing on the relevance of the information. Okay. So, for instance, let's say it's the Environmental Protection Agency. Do they need to look at your human resources records to see how many of your workers have children? Probably not. All right, that's probably going too far. Okay, how many of your work? Let's say it's a point source issue in regard to the Clean Air Act. How many of your workers drive electric vehicles? It's just not relevant. But again, very broad statutes, very tough to attack. Most administrative agencies will kind of do a balance on their own, the cost-benefit analysis, as well as what is it we really need to know versus the burden placed on the regulated party in terms of cost to produce these things, documents especially, or even a subpoena to testify when you think about the time you have to take off work and travel and things of that nature. But again, for the most part, you're going to lose. So let's move to a search warrant. Now, the reason I mentioned the attacks on a subpoena, what a regulated party can do to attack a subpoena or an inspection, that's a little bit easier to do. When it comes to a search warrant, you're just flat out going to lose, right? Now, if you remember from way back when we were looking at the Fourth Amendment, a search warrant is based on probable cause, okay? And probable cause, if you remember, to search business premises is a lot easier to establish, right? Supreme Court, if you mentioned many moons ago when we were looking at this, the Supreme Court says you have a lesser interest in privacy in the corporate arena, the plant, factory, office building, than you do your own personal home. So it's much easier to get these kinds of search warrants. So you'll probably lose. Now, however, if you're issued a search warrant, then things have changed considerably. The matter may very well be interpreted by the administrative agency as something to be criminal. All right, so again, this is when you contact counsel right away. Actually, of course, you should contact counsel in any one of these situations, but admittedly, the urgency is much greater here. Now, also remember from way back when we were looking at the Fourth Amendment, we were talking about highly regulated industries where you don't even need a search warrant. Right? The very fact that you have a license to perform that particular service or build that or manufacture that type of good, all right? You've waived your Fourth Amendment rights. We talked about gun shops. We talked about those who have liquor licenses. Anytime there's children involved, things of that nature, any potential harm to children, you've waived that protection. Okay, so let's go ahead and look at adjudication. So for the most part, what we're going to assume now, right, is the agency has written the law, right, written the rule. They've inspected as to whether you violated it or not. Now they think that you have, and now we're going to go through the adjudication process. Okay, now, most, and I mean this seriously, it's really more of a super majority. All right, most administrative actions that reach this point are settled through simple negotiation. Very informal. Meetings with regulators and those representing the regulated party, and generally you can get these things knocked out very, very quickly. Okay. Always good to settle, especially when it's very clear you're in the wrong. You avoid bad publicity, all right? And you'll see why here in a minute. You look like you're cooperative. You're preserving your resources. Again, anytime you have to use counsel, inside, outside counsel, or any other expert or agency or consultant or whatever, it's going to cost money. So if you can save yourself from bad publicity, save your resources, and look like you're still being cooperative, it's generally the best thing to do. And again, a lot of times you might learn something. You might learn a way to perhaps save yourself a lot of heartache in the future. Okay, now let's assume that a negotiated settlement was just not possible. Couldn't get it done, okay? Well then, a formal complaint will be filed, all right? Now, filed where? With the administrative agency. So the administrative agency files a complaint with its own administrative agency, okay? So again, as we'd mentioned just a few minutes ago, how powerful administrative agencies are, they can certainly work within themselves, right? Writing the rule, investigating whether you violated it, and putting you through their own adjudication process. Okay, so what happens to the formal complaint? Number one, and probably most painful for the affected party, it's now public. What's great about a negotiated settlement is you keep the private private. Now the private has become public when a formal complaint has been filed. Okay? Now, you don't look cooperative. You're facing bad publicity, right? Your public relations might take a hit. Your stock price might take a hit because investors might get worried that you're going to be in litigation for quite some time, maybe shut down, etc. And you're certainly not preserving your resources because, as we just mentioned a few seconds ago, you've picked up the phone, you've talked to inside counsel, outside counsel, consultants, experts, that kind of thing, and it's going to get pricey. Okay, now, let's talk just a little bit about the hearing. Okay, now, whether you're going to have a formal complaint, or I should say it the other way around, when you're going to have a formal complaint, all right, there's an informal hearing and a formal hearing. Okay, now there's a negotiated settlement, that's different, we're past that. Okay, but when you get to a formal complaint, the hearing itself can be informal or formal. Now, in comes the administrative law judge. Now, the administrative law judge, all right, works for the administrative agency, all right, is supposed to be impartial and generally is. I mean, that's the one thing, it sounds bad, right? The fox guarding the hen house to a certain degree. But the administrative law judge, I mean, you should have a lot of faith in him or her in the sense that they tend to be very impartial. I mean, many orders have gone again, these binding orders have gone against the agency from time to time. Okay, now, let's look at the informal hearing. Now, the administrative law judge will issue an oath, take on evidence, hear from witnesses, and certainly can make a determination of fact. All right? So it sounds a little bit like a trial, right? It's informal. Now again, everything's public though, all right? We're past that. You decided not to negotiate a settlement, so we're past that. But issuing oaths to witnesses, listening to testimony, taking in forms of evidence, etc., and then making a decision, okay? Now, if it's formal, it's all of those things with a little bit more. The difference, the key difference between the formal process and the informal process is in the formal process, you have everything that we talked about in regard to the informal process, right? Witnesses, taking oath, right? Submitting evidence and determination of fact. But now you've engaged, you can rather engage in discovery. Now, if it's informal, you just come with what you already have. if it's formal, discovery means, if you remember from a few weeks ago, you learn more and more about the other side's case, right? So you can ask the other party for information. If it's informal, you can't do that. If it's formal, then you're asking the other party for more information. So depositions, interrogatories, right? It's the discovery process. E-records, right? Again, this is where things get hairy. More information is out there, and now, of course, more information is public. So you start to scratch your head a little bit and say, now wait a minute, boy, I tell you what, that negotiated settlement sure seems a lot better. And by the way, you don't get to choose whether it's going to be informal or formal. Once that formal complaint's filed, there's not much you can do. Okay, now with that said, all right, one of the things that that administrative law judges can do that courts cannot do, Article 3 courts, state courts, doesn't really matter, is that they can use hearsay, okay? Again, in an Article 3 court, can't do that. State courts, you can't do that. In an administrative hearing, hearsay is admissible. So again, more and more that's public. The negotiated settlement looking pretty good probably at this point. Okay, now, the order, if you look at your outline, the order is basically the administrative law judge's decision that will bind these two parties. And most of the time, it's a regulated party, right, ABC Inc., and the administrative agency itself, the Federal Trade Commission, Securities and Exchange Commission, National Labor Relations Board, OSHA, right, what have you, IRS, doesn't really matter, okay? Now, could it be two disputing parties? That's certainly possible. So it could be ABC Inc. and XYZ Inc., all right, Incorporated. Certainly possible, okay? But these agency orders are binding, and they're only binding, however, on the two parties. Now, can you appeal the administrative law judge's decision? The answer is yes, all right? And we won't get into the hairy details as to how the appeal is made, but I just want you to know it could go to one of two places. The appeal can either go straight to a federal appellate court, right, the Circuit Court of Appeals, or it could go straight to a federal district court if a trial de novo is required. And a trial de novo means basically we start over, we kind of throw out the record in the administrative hearing, we kind of pretend that it didn't take place. When you do the first appeal, right, straight to the federal appellate courts, then the record is intact. So everything that happened with the administrative hearing is still intact. So if you're appealing, right, from the administrative law judge's decision to the federal appellate court, you're losing going in, right? You're losing going in. If it's a federal district court, because a trial de novo is required, then essentially it's tie, or it's like you're starting over. Nothing really happened. Okay, now, what we've looked at so far is essentially a lot of heat, I think you would say, for the regulated parties, right? What we haven't done is kind of flip things a little bit and looked at some limitations on administrative agencies, at least one way or another. And what we're going to do is we're going to talk about 7 forms of law. Actually, some of them are specific statutes we're going to look at the federal level, but these the specific statutes we're going to look at very much have a state, and I should say, be careful, most states have a counterpart to them. So you can kind of bank on the fact that this is the case as well. Okay, so let's go ahead and start with the Freedom of Information Act. Now, this is a statute that's actually been amended several times, but its origins date back to 1966. And basically what it is, it's just what it sounds like, all right? Any interested party, affected or not, you don't have to be affected, you don't have to be regulated by this agency. You can merely just say, I'm interested, I'm an interested party, which includes, of course, non-citizens as well, right? You know, let's say an Austrian business person wants to look at federal government records here in the United States. They can certainly do so. Okay, now, with that said, all right, any government record any government record is subject to the Freedom of Information Act unless there's an exception, all right? Now, there are some exceptions, but they are rare, okay? Now, individuals like you and I generally don't ask for records, right? Businesses do. Trade groups do, all right? Other governments do. Okay, could be state governments, local governments, or another national government, right? Media certainly does, okay? Now, all these records now have to be available on the internet as well. Now, that's a good thing for the agency because they just don't have to take these requests. They just throw it up online and say, hey, go find it, and here's how you find it. So, you know, it's kind of reduced some of the production costs for those documents. Now, one of the things to keep in mind with FOIA, as it's called, right, Freedom of Information Act, there are very few exceptions. I will give you one. Anything dealing with national security is exempt, right? So you're not going to get to look at FBI records and CIA records when you want to, right? The federal government would really have to go out of its way to declassify those things. But for the most part, if you want it, you can take a look at it, right? But the idea was to kind of open up government a little bit. Okay. Now, the Small Business Regulatory Enforcement Act of 1996, I guess I had alluded to it a little bit earlier. What it does is basically gives small businesses an extra 30 days no matter what before a final rule becomes applicable to them. All right. Now, the belief at the time was, and actually still is that smaller businesses might need a little bit more time to get ready to change, right? They're smaller economies of scale and scope. They need a little bit more time, fewer resources. So any final rule cannot take effect on a small business for at least 60 days. Now, again, the administrative agencies can certainly go further than that, and they could say 5 years, and then it applies to everybody in 5 years. Okay, now, small businesses, we're not going to get into all the details as to how a small business is defined, but a small business for the most part is defined by how many employees it has. Okay, so it could be 15 employees, 20 employees, and there's some differences based on the size and the industry. So we're not going to get into that, but just know that small businesses have a little bit more time to comply. Okay, now let's look at the Regulatory Flexibility Act. Okay, now this is actually a federal statute, much like the first two, by the way, both federal statutes with state counterparts. This also has a state counterpart. What it really is an alternatives law. Okay. Now, it also helps small businesses. Now, this statute's actually older, about a decade and a half older. This is 1980. A decade and a half older than the Small Business Act that we just looked at here a little while ago. But what it does is it forces the administrative agency to take a deep dive into alternatives. So maybe this is the final rule, but the administrative agency has to identify several alternatives and then explain why these alternatives won't work. All right? Now, when does the administrative agency have to do this? The administrative agency has to do this deep dive into alternatives and explain why they won't work anytime a large number of small businesses may be affected. Now, how are small businesses defined? They're defined by how many employees they have for the most part. There are some differences. We're not going to get into that. But just know, if a final rule is promulgated, right, comes out, it's published in the Federal Register, and it's going to affect many small firms, well, that administrative agency really isn't done yet. I mean, that's the final rule, but now you got to go through all the alternatives that were possible and then explain why those just simply won't work, right? Why this is the best way to go. Now, you might say, well, what's the big whoop? Wouldn't they do that anyway? I mean, wouldn't they look at some alternatives? Sometimes yes, sometimes no, but for the most part they would. However, the brilliance of this statute, if you're a small business, is that you can now attack an administrative agency's action by arguing, wait a minute, that alternative would have been better. That alternative would have been better. That alternative would have been less burdensome, which is a standard you're going to find in a lot of administrative law as well as statutory law. All right, what is less burdensome? Not as damaging, less of a concern. Okay, that type of thing. So you might, if you're scratching your head thinking, well, gee, the real impact of that is probably just slowing down the application of the promulgated final rule, and that's exactly right. I mean, that's what it does. It really gives the small business a few bites at the apple, if you will. Attack each one of those alternatives and say, these these might be better. Why don't you look a little bit deeper into this? Isn't this less burdensome in terms of an alternative? Okay, let's look at sunshine laws. Okay, there's several government in the Sunshine Acts, all right, ACTS, that you're going to find at the federal level as well as the state level. Okay, basically, this is a meeting law, all right? If you have a government meeting, everybody has the right to show up. It's that simple, all right? Government meeting, everybody has the right to show up, okay? Now, this is Congress, administrative agencies, and at the state level, since there are state counterparts, the state legislature. You can't kick people out, the public, out of the state legislative meeting or committee meetings, right? Or state administrative meeting. You can't kick people out. The whole point was, you know, government in the sunshine. Everybody can see it. It's like, oh, right, it's in the sunshine. You can see it. Now, with that said, there are some exceptions, right? And they're all related to national security and criminal justice, okay? Now, there's a couple that I think are noteworthy. Grand jury proceedings, right? When we're considering, we being, you know, the prosecutor, considering the charging of somebody with a crime through an indictment, that is obviously closed. Anything dealing with national security will be closed. Anything that's in any meeting that might anticipate future litigation can be closed. But frankly, those are actually very few meetings, all right? For the most part, if we're having a meeting, people have a right to, I mean, I just, you know, as the dean of Wayne College, if I have a faculty meeting, I can't kick anybody out. That's covered, right? Okay, now, open records laws, okay? Several at the federal level, several state counterparts, so we're just kind of looping them all together, just like we did with sunshine laws. Okay, so, sunshine laws, meetings. Records laws, just what do you think? Records. Could be paper records, e-records, etc. Okay, open records laws. Okay, now, you might scratch your head and think, well, doesn't FOIA take care of most of that? It does, okay? But the reason I want to mention the open records laws is, in terms of that moniker, in terms of that phrase, is that's what you're going to find at the state level, okay? Is it covered by open records laws? Right? That's the big question. Is it covered by open records laws? And for the most part, unless it's national security or criminal justice related, and even the latter category, criminal justice related, is fairly narrow, you're going to have access to it. Okay? You know, at a public university, everything's pretty much open. I mean, if you want it, you can see it. Yeah, you don't need a reason. And, you know, now that I think of it, let me make that very, very clear. If it's FOIA, sunshine laws, open record laws, things like that, you don't need a reason. You just say, I want to see it, or I want to be there. I want to be in the meeting. I want to see the record. The reason for that, by the way, is that, you know, Congress, when writing the statutes, or state legislatures, when writing the statutes, didn't want to put courts in the position, and rightfully so, of trying to decide what was a good reason and what wasn't. It's just, you know, we'll have these records that are open, these meetings that are open, or they're not, right? And there might be some categorical exceptions. Okay, the Equal Access to Justice Act. Now, this statute is actually pretty large. It did a lot of different things. But the one part, for our purposes, that was in it was basically a provision saying administrative agencies, and really the government in general, cannot harass people. Right? And probably the classic example of this is constantly bothering people, individual citizens or businesses, right? Firms, affected parties, for records, saying we need this, we need this, we need this, we need this. And basically what the Equal Access to Justice Act has said, hey, look, if another administrative agency has these records, don't pester somebody. Just go give that to that administrative agency. Right? So if the EPA wants some records that OSHA has, the EPA can't bother me about it. EPA has to go to OSHA and say, hey, OSHA, can I have some of those records? Oh, yeah, sure, here you go. Right? The fear was, I'm not even really sure it was realized, the fear was that administrative agencies would harass and pester. Okay, now, if the actions by that administrative agency are extremely outrageous, I mean, it has to be pretty bad. I mean, just asking for records, I guess I'm probably making it a little bit simpler than it really is. But if it's a constant pest or constant harass harassment, then you actually can sue the administrative agency just on those grounds. So you're not attacking why they're looking for it. You're not attacking the substance of whether the rule makes sense or not as to what would create a request for that information. You're just saying, hey, you're harassing me. All right, and you can certainly win as well. And again, you get a lot of class action suits like that. Okay. All right, now, this last part, and you see I have in parentheses various, privacy acts. At the federal level, at the state level, we have a lot of those, so I'm kind of looping them together, just like I did with sunshine laws and open records laws. But essentially, what it does is it gives people privacy in terms of how their records are handled. So you think about how many administrative agencies have records on me, right? The privacy statutes we're talking about here, the privacy acts, protect how that information is handled. Okay, first of all right, there's really three key provisions, so just to kind of give you a little heads up. First of all, administrative agencies only need records on me for what's necessary to their purpose. Okay, now I have a house, right? Do they need to worry about point sources? Does the EPA have to worry about having records on point sources of possible pollution coming from my house? Of course not. All right. It wouldn't make any sense, all right? Okay, so again, only what's necessary. Number two, and probably more importantly, so number one, only records that are necessary. Number two, I have to have access to my records. If I want access to my records, I get access to my records, okay? Maybe somebody might not have access to my records, but at least I have access. And number three, very much related to number two, is that I should have the ability to correct misinformation. Right? So I get access to my records, and again, number one, you're only supposed to have the information you need, right? Number two, right? Well, I should have access to it. But number three, if I find out there's a problem, there's an error, I should be able to fix it, right? Now, I have to come up with the documentation, of course, to show that it's wrong, but I'm probably not going to try to correct it if I think I'm wrong. I mean, it just doesn't make sense. I think the administrative agency is wrong, right? Okay, so again, only information that's necessary, access to my records, right, and the ability to correct them. Okay, so that finishes up administrative law. Thank you very much.